Seller's Disclosure Statement of the Greater Kalamazoo Association of Realtors. Applicability of seller disclosure requirements. The seller disclosure requirements apply to the transfer of any interest in real estate consisting of not less than one or more than 4 residential dwelling units, whether by sale, exchange, installment land contract, lease with an option to purchase, or ground lease, coupled with proposed improvements by the purchaser or tenant, or a transfer of stock or an interest in a residential cooperative. Seller disclosure requirements exceptions. The seller disclosure requirements do not apply to any of the following. This is an important list to understand when you don't need a seller's disclosure statement. A. Transfers pursuant to court order, including but not limited to transfers ordered by a probate court in administration of an estate, transfers pursuant to a writ of execution, transfers by any foreclosure sale, transfers by any foreclosure sale, transfers by a trustee in bankruptcy, transfers by eminent domain, and transfers resulting from a decree for specific performance. B. Transfers to a mortgagee by a mortgagor or successor and interest who is in default, or transfers to a beneficiary of a deed of trust by a trustor or successor and interest who is in default. C. Transfers by a sale under a power of sale or any foreclosure sale under a decree of foreclosure after default in an obligation secured by a mortgage or deed of trust, or secured by any other instrument containing a power of sale, or transfers by a mortgagee or a beneficiary under a deed of trust who has acquired the real property at a sale conducted pursuant to a power of sale under a mortgage or deed of trust, or a sale pursuant to a decree of foreclosure, or has acquired the real property by a deed in lieu of foreclosure. D. Transfers by a non-occupant fiduciary in the course of the administration of a decedent's estate, guardianship, conservatorship, or trust. E. Transfers from one co-tenant to one or more other co-tenants. F. Transfers made to a spouse, parent, grandparent, child, or grandchild. G. Transfers between spouses resulting from a judgment of divorce or a judgment of separate maintenance, or from a property settlement agreement incidental to such a judgment. H. Transfers or exchanges to or from any governmental entity. I. Transfers made by a person's license under Article 24 of Act No. 299 of the Public Acts of 1980. Being sections 339.2401 to 399.2412 of the Michigan Compiled Laws of newly constructed residential property that has not been inhabited. In other words, any new construction that has not been inhabited will not require a seller's disclosure statement. Disclaimer: this form is provided as a service of GKAR. Please review the form and details of the particular transaction. GKAR is not responsible for use or misuse of the form for misrepresentations or warranties made in connection with the form. The second page of the seller's disclosure statement will indicate the property address, street, city, village, or township in Michigan. This top portion of the form should be filled out by your seller and should not be filled out by any agent. Purpose of statement. This statement is disclosure of the condition of the property in compliance with the Seller Disclosure Act. This statement is a disclosure of the condition and information concerning the property known by the seller. Unless otherwise advised, the seller does not possess any expertise in construction, architecture, engineering, or any other specific area related to the construction or condition of the improvements on the property or the land. Also, unless otherwise advised, the seller has not conducted any inspection of generally inaccessible areas such as the foundation or roof. This statement is not a warranty of any kind by the seller or by any agent representing the seller in this transaction, and is not a substitute for any inspections or warranties that the buyer may wish to obtain. Seller's disclosure. The seller discloses the following information with the knowledge that even though this is not a warranty, the seller specifically makes the following representations based on the seller's knowledge at the signing of this document. Upon receiving this statement from the seller's agent is required to provide a copy to the buyer or the agent of the buyer. The seller authorizes its agent or agents to provide a copy of this statement to any prospective buyer in connection with any actual or anticipated sale of property. The following are representations made solely by the seller and are not the representations of the seller's agent. This information is a disclosure only and is not intended to be a part of any contract between buyer and seller. Instructions to the seller. 1. Answer all questions. 2. Report known conditions affecting the property. 3. Attach additional pages with your signature if additional space is required. 4. Complete this form yourself. 5. If some items do not apply to your property, check not available. If you do not know the facts, check unknown. Failure to provide a purchaser with a signed disclosure statement will enable a purchaser to terminate an otherwise binding purchase agreement. It should also be noted that if at any time during the process of a sale that something may occur or change within the seller's disclosure statement, it's imperative that the seller provide an updated seller disclosure, sign it, and provide you a copy so that you may forward it to any potential buyer. Appliances, systems, services. The items below are in working order. The items below are included in the sale of the property only if the purchase agreement so provides. This is important that agents understand that just because an item is marked yes on the seller's disclosure, it does not mean it's part of the purchase agreement or buy-sell agreement. It's imperative that an agent understand that if a buyer agent wishes to have an item included, it must be within the buy-sell agreement. You'll see the boxes below are there for your client to indicate whether the items are in working order with either a checkbox for yes, no, unknown, or not available. Below is a spot that says explanations. This is where clients can actually put additional information about what they may have marked up above, or if they need additional sheets of paper, they can also attach it to this document. States here, unless otherwise agreed, all household appliances are sold in working order except as noted without warranty beyond date of closing. Below you'll continue to see multiple questions, 12 questions for the seller to read and acknowledge and answer to the best of their ability. You will also see below here where it says the seller has lived in the residence on the property from blank date to blank date, and the seller has owned the property since blank date. Also goes on to state here that the seller certifies that the information in this statement is true and correct to the best of seller's knowledge as of the date of the seller's signature. Again, if a home has been listed, let's say it's been 60 or 90 days, and all of a sudden maybe there's flooding in the basement, we would encourage that the seller redo a new seller's disclosure indicating any change that may have occurred within the home. There's a spot there for that seller to sign and date, and this information would then be listed within the MLS and uploaded into the MLS as a document for any future buyer to be able to download and also execute and provide the buy-sell agreement, a seller's disclosure, and lead-based paint document to the listing agent.